sanction is to remove unnecessary litigation against the people, my lords. And my lords, as section 196 and 299 involve the public order, the disharmony, this section 217 has been put forth, my lords. If my lords are with me on that, may I proceed? Grateful, my lords. Coming back to the point where I was suggesting. Coming back to the point that if the authorities central government or the state government do not have any kind of investigative material to act upon, they cannot grant a sanction. This would create a situation where the cart is put before the horse, my lords. Now, my lords, the second limb of my argument being that since the charges were framed while the quashing petition was pending, this point ought to have been brought to the court's attention by the respondents, my lord, to seek some kind of stay or to just apprise the High Court, the Honorable High Court, regarding the change in the stage from investigation to framing of charges, my lords. And the very fact that the framing of charges was done by the magistrate, it shows that prima facie case existed, prima facie investigative government or the state government do not have any kind of investigative material to act upon, they cannot grant a sanction. This would create a situation where the cart is put before the horse, my lords. Now, my lords, the second limb of my argument being that since the charges were framed while the quashing petition was pending, this point ought to have been brought to the court's attention by the respondents, my lord, to seek some kind of stay or to just apprise the High Court, the Honorable High Court, regarding the change in the stage from investigation to framing of charges, my lords. And the very fact that the framing of charges was done by the magistrate, it shows that prima facie case existed, prima facie investigative material was there against the respondents, my lords. Now, my lords, it is on record that the FIR also pertains to two sections of IT Act, that is 66C and 66D. My lords, it is an admitted fact that both of these offences are cognizable, do not require any sanction. So, my lords, it is a settled principle laid down by this honourable court itself that where any FIR discloses multiple offences arising out of the same transaction, and even one of those offences is cognizable and does not require a sanction, the police have an unfettered right to investigate, my lords. Now, my lords, arguendo, just a contention put forth that the respondents may claim that the section 173 subclause 3 of BNSS provides for a preliminary inquiry. My lords, it provides that the offence is punishable with the punishment of between 3 to 7 years. The police have a discretion, my lords, they have a discretion to conduct a preliminary inquiry of 14 days, my lords. Now, my lords, the purpose of this preliminary inquiry introduced by this present BNSS was to ascertain whether the FIR contains any cognizable offence, my lords. It has been established by this court itself in plethora of judgments, my lords, that if prima facie cognizable, my lords may have flag 2 of the compendium. Internal page 17, my lords, this is a very recent judgment by Justice Oak and Justice Ojal Goyan back in 28th March 2025. My lords, I'll just read the relevant portion. It has been highlighted for my lords' reference. My lords have it. Internal page 17, my lords.
Any locus classicus on this?
My lords, the council is restricting to the fact that for a the objective of preliminary inquiry is to ascertain whether a cognizable offence has been committed. The preliminary inquiry can be done by the police officer. It is a discretionary power.
I was just asking you if you are aware of any landmark judgment. Although it has become statute now.
My lords.
But still that judgment is still green.
My lords.
Because the cases, the facts have been mentioned in the judgment.
My lords.
What kind of cases the preliminary inquiry is required to be made?
My lords, in fact, Constitution Bench, Lalita Kumari, my lords. It, may I read it for my lords?
This is what I was expecting.
My lords. If my lords are satisfied with the third issue, may the council proceed with the fourth issue? Please, my lords. My lords, now the fourth issue pertains to whether
And any judgment on this sanction?
my lords,
That at what stage sanction is required to be submitted to the court?
my lords,
Which is the first stage when the court is said to be taken up for cognizance of the
as per the limited knowledge of the council, the sanction is required when the magistrate first applies his mind, my lords.
It may be magistrate, it may be session court.
My lords, when the court takes the cognizance and applies its mind for the very first time, my lords.
Magistrate in all the cases takes cognizance of the offender first when he is subject to bail
My lords.
or he is arrested.
My lords,
The
at
trial court takes the cognizance of offence.
My lords.
At what stage you suppose a trial is sessions tribal case?
My lords.
At what stage, first stage you consider that cognizance is taken by the court?
My lords, as per the limited knowledge of the council, it is at the framing of charges.
Why?
The stage of framing of charges. Because at that time, the court has reviewed the initial investigative material, the challan filed by the police under section 193, and then the court takes the cognizance and frames the charges required. My lords. If my lords are satisfied, we have proceed with the fourth issue. My lords, now the fourth issue pertains to whether the acts complained of fall under the umbrella of Article 19(1)(a) or fall under the ambit of Article 19(2), my lords, which is an exception to Article 19(1)(a). Now, my lords, this particular article guarantees freedom of speech and expression, but Article 19(2) enables the state to impose reasonable restrictions, my lords, meaning thereby that protected speech is any expression that does not violate sovereignty, security, public order, decency, morality, defamation, or incitement of an offence, my lords. Now, my lords, it is a qualified freedom that has been established. So, my lords, Article 19(2) provides for supremacy of law and welfare of the people before the welfare of the state before the people, my lords. Now, my lords, the first limb of this particular issue being that right to free speech does not include right to deceive, my lords. My lords, it is an admitted fact, it is on record that PJF was created on 3 different platforms: X, that was Twitter, Instagram, and Telegram, my lords, where they impersonated an IPS officer, used his name, and further used the insignia of Punjab Police, my lords. Now, my lords, all of this is taken under the same roof, my lords. It constitutes a crime. It constitutes a crime under Section 66D, my lords, as they impersonated, as they cheated the citizens, my lords. Now, my lords, if my lords could have flag 2 of the compendium, my lords. Flag 2 of the compendium, internal page 25, my lords. Flag 2, internal page 25, my lords.
Para 8?
My lords,
Para 8?
Para 8, my lords. It is of the utmost importance to keep all speech free in order for the truth to emerge and have a civil society. freedom of speech and expression guaranteed by Article 19(1) of the Constitution is a very valuable fundamental right. However, the right is not an absolute right, my lords. So, my lords, the second limb of my argument being that welfare of the people is the supreme law, my lords. The larger interest and welfare of the society has to be considered and protected, my lords. Now, my lords, in the present case, as has been established by my co-counsel and myself as well, that PJF has been admitted to be connected with the respondents. They have impersonated a serving IPS officer, used his name, used the insignia of Punjab Police. Therefore, they fall under the ambit of Article 19(2) as they fall under the ambit of incitement of an offence. Furthermore, they destroyed the public harmony, my lords. And my lords, this is not mere criticism. This cannot be termed as mere criticism. The points, if my lords could have the Moot proposition. My lords, the fourth point. It states that they disseminated calls for mass disobedience, refusal to comply with lawful government orders, my lords. All of this taken all together constituted this offence, my lords, and this whole facts fall under the ambit of Article 19. Now, if my lords are satisfied with this issue, may the council proceed with the prayer? Wherefore, it is most humbly pleaded and implored before the Honourable Supreme Court of India, in light of facts and circumstances of the case, issues raised, arguments advanced, and authorities cited, the Council, on behalf of the petitioner, prays that Honourable Court may be pleased to set aside their Pune judgment dated 5th September 2025, restore the FIR and all consequential proceedings, my lords, and pass an order directing that the trial be conducted in accordance with law, my lords. It was an honor assisting this meeting. Great.
Council seeks permission to approach the dais. Much obliged. The council seeks permission to address the bench collectively as your lordships. Much obliged, your lordships. Your lordship, with your permission, can the council submit the compendium on behalf of the respondents? Much obliged, your lordships. May I, your lordships? Your lordships, we have approached the honourable.
That the council want to contend is that in this present matter there were certain inferences that were taken into consideration and the freedom of speech and expression was taken into consideration, Your Honor. The prosecution has admitted that no disturbance whatsoever was caused by the raising of the slogans by the appellants, that in spite of the fact that the appellant slogans were raised a couple of times, the people were unaffected and carried on their normal lives. In this present matter also, Your Honor, the people carried on their normal lives. They did not have the likelihood and the comments made by them. And in this present matter, this is just an electronic mode of communication that is prevalent in this times, Your Honor. And the electronic modes of communication did not have the reasons and likelihood of inciting the general public. Therefore, they were squarely exercising their right under Article 19, Clause 1, Subclause A, and there was no reasonable restriction to put on under 19, Clause 2. Therefore, Your Honor, this is just a targeted attack on the political dissent without anything same. And the progress of the matter also, Your Honor, cannot cure a jurisdictional defect at the inception. Charges were framed only during the pendency of the quashing petition, but the same has to be taken consideration that the observations of the High Court was that from the very instance, from the ab initio, there has been an abuse of process, and the absence of sanction at the FIR stage has made the proceedings an abuse of the process from the very proceedings also. The High Court's power under Section 528 BNS is not fettered by the stage of proceedings, Your Honor. Therefore, humbly contending the same. If my lords are satisfied with the submission made by the Council on Issue number 4, may I proceed to the prayer, Your Honor. Much obliged. Wherefore, in the radiance of the facts, issue raised, contentions progressed, and authorities cited, the Council for Respondents modestly requests the Honorable Supreme Court to dismiss the present appeal filed by the appellant, uphold and affirm the judgment and order dated 5th September 2025, passed by the Honorable High Court, quashing FIR number 112/2025, registered at Police Station Cybercrime Mohali, hold that the continuation of criminal proceedings against the respondents would amount to an abuse of process of law and violation of their fundamental rights, and or render any order, judgment or direction that the Honorable Court may deem fit in the best interest of justice, fairness, equity and good conscience. For this act of benevolence, the Council for the Respondents as a duty bound shall forever pray, all of which is respectfully affirmed and submitted by the Councils on behalf of the respondents. Much obliged, Your Honor. It was an honor assisting this court.
My lords have already undergone a lot of tedious paperwork, but I'll take just 4 minutes precisely. Grateful, my lords. My lords, I'll precisely take 4 minutes of my lord's time. And my lords, coming to the fact that it had rightly followed from this court itself that at stage of filing of challan, the respondents could have undertook the option of discharge, my lords, for that fact. And then, my lords, the petition itself would have been rendered infructuous for the fact that there was no amendment of petition, my lords. Because, of course, if challan has been presented, charges have been framed, the petition ought to be amended for that fact, my lords. The prayer needs to be
That
amended.
I already pointed out.
Grateful, my lords. And insofar as sanction is concerned, my lord, the impugned judgment is completely silent on that fact, my lords. And the Moot proposition clearly states that, my lords. Secondly, my lords, it is not the case of the respondents that they have not disseminated information. It is.
Sanction is not required to be considered by the High Court exercising the inherent powers. Sanction is only permission
Indeed,
so
my
that
lords.
the abuse of the criminal system is not done.
Indeed, my
That a
lords.
person can be subject to trial. This is the only limited purpose of this sanction.
Grateful, my lords.
Otherwise, if the High Court is of the opinion that the entire continuation of proceeding will amount to abuse of process of law, it may go on to quash the FIR and subsequent proceedings even if the sanction order is not considered. That was meant for the trial court only.
Indeed, my lord. My lord, that is exactly what the council is contending. My lord, that sanction is irrelevant to this fact, my lord. When caution is being considered, my lord. And admittedly, my lord, it is the respondent. It is not their case, the respondent's case, that we have not put forth that information. It is their case that it covers under the ambit of freedom of speech, my lords. My lord, the ambit of freedom of speech does not entail impersonating a serving IPS officer, my lords, using his photo, using his name, my lords, and then disseminating information, my lords, which is not just, it is not a civic debate, my lords, they've called for civil disobedience of lawful public orders, my lords, and then representing themselves as insider of state administration, my lords, portraying themselves as part of the government, my lords. They're saying that the state is discriminating between certain communities and groups, my lords, again on record, my lords. And to that fact, my lords, the judgments which have been relied upon by my learned friends, my lords, those clearly state the statements made in those were on the face value. It involves it involves journalists, my lords. In this case, they have not made the statements on their face value. They're portraying their incenting themselves, my lords. And very lastly, my lords, the fact that algorithmic spread of the information, my lords, insofar as intermediaries concerned, my lords, the fact that the apps like Instagram, Twitter, my lords, provide paid basis on which the content can be spread over to certain parts of the country, my lords. And this, my lord, the case of the respondents seems to be fit for a matter of trial, my lords. My lords, at the stage of quashing of FIR, the essential ingredients cannot be undergone by this honorable court. If my lords are satisfied, we are grateful, my lords. It was an honor assisting.
Your Honor, the seek permission to oppose the ties for subject.
For rejoin, they rejoin.
For the sir rebuttals, Your Honor, to the scene. There were certain contentions that the council would like to.
But there will be no end to it.
There will be no end to it.
It cannot be rebuttal for rebuttal.
Your Honor, as a matter of right, we were granted 4 minutes of the time for the sir rebuttal, so just wanted to exercise the same.
Sure.
For the stream, just listen. That is the 4. Your Honor, just council speaker number 2 will be just taking 2 minutes of your time and the 2 minutes by speaker number 1 for the same. Coming to the same, Your Honor, talking about the intermediaries and talking about the connection of the respondent number 2 and 1 with the PGF channel, Your Honor. Nothing on the record has mentioned that the certification under section 63 BSA clause 63 clause 4 of the BSA, that was prior 65B, that requires the certification for the electronic evidence that the device from which the same has been mentioned has been taken into consideration by the Honorable Court.
That the Supreme Court has come, it can be given at any stage of trial.
That can be taken at any stage of the trial, Your Honor, but the same was not placed on record. That's why what we are contending. Therefore, the same, whether the connection between the respondents and the PGF channel was there and the same was being administered by them, is a matter that has to be determined at a later stage, not in this matter, present matter. Now coming to the other part of the Your Honor, the same offences is not solely on the basis that the political dissent was covered under Article 19(1)(a), but also on the matter that the offences that has been mentioned in Section 196 and 299, the ingredients, basic ingredients of the same have to be taken into consideration. Therefore, the complete FIR has to be taken into consideration. That's the submission of the. Would like to call Speaker number 1 first. Much obliged.
Permission, may the
Yes,
council
please,
coach.
please.
Much obliged. Your Lordship, with your kind consideration and permission, the council would not delve into the facts and the submissions which have been done earlier. It's just the points of notice which needs to be recognized here, and those stands. Your Lordship, the learned friends very well highlighted right back that with regards to the submissions were mainly curtailed to the Article 19. Your Lordships, here it's just being presented that if the FIR on face of it is presumed to be true, the prima facie needs to be established in such a manner that at least the FIR alone, without the inquiry which has been done, stands just to provide an independent offence as such. But if the FIR is lacking those very ingredients, so at that point of time, the High Court didn't get into the trial procedures. The High Court's limited inherent powers with regards to 528 and 482 erstwhile of the CRPC stands right. It was just a manner wherein the abuse of process of the same was to be curtailed. So thereby High Court just took into consideration that the quashing stands very necessary in the case, considering the same was not to be appreciated on the basis of any kind of absence of sanction or anything. It just limited itself to the scrutiny of the FIR, ingredients being analyzed, and the checking of the legality. So thereby nullifying the same. Now coming to the conclusive point of the same, with your kind permission, Your Lordship, it is majorly about the section 66C, D, 196 and 299. With the permission, just 30 seconds and concluding, Your Lordships. Your Lordship, the 66C and D, it very well highlights that we need a computer source to verify from where the same has been done. Your Lordship, but the proximate nexus between the respondent number 1 and 2 was missing. So thereby nullifying the 66C and D of the ITM 2000. Your Lordship, now coming to the fact for 196 and 299, it was just the mere coincidence that these are being interacted, and on a colorable factor that the expression which is being done, it doesn't promote any kind of enmity, and there is no religion-based attack on any kind of thing. It was purely agrarian and towards the unlawful things being done, and it was the agitation by the people against the government exercising their right to protest in best interest of justice and good conscience, which the Grandnorm Constitution and the Honorable Supreme Court, the Temple of Justice, Apex Court, always protects. Much obliged, Your Lordship. It was an honor to plead. Thank you so much.
Marking. But we have made sure that we will make a close marking, not discouraging any of the parties. So it was not on the merits of the case, it was just on the based on the performance of the parties. So all the rest was not very okay.
this juncture, I would like to extend our dignitaries who have graciously joined us today. Thank you, sir. I request everyone present here to kindly put your hands together in appreciation and welcome our distinguished guests. Thank you. We are honored to welcome our esteemed chief guests of the day. We have with us Shri Dinesh Verma, District Attorney Punjab, Advocate IPS Sabharwal, Deputy Advocate General Punjab and Haryana High Court, Advocate Akhil Kashyap, Supreme Court and Punjab and Haryana High Court, Advocate Mandeep Kumar Jethi, Districts and Sessions Court Ludhiana, Advocate Dashwinder Singh, Districts and Sessions Court Ludhiana. We're all honored to have you with us, sir. Thank you. Your presence surely adds immense value and prestige to this occasion, and we're truly honored to have you all amongst us. Let's have a big round of applause, everyone. At this juncture, it is my proud privilege to invite our Registrar Sir, Mr. Sanjay Khanduri, to deliver the welcome address. Sir, your visionary leadership and unwavering commitment to academic excellence continues to inspire us and guide this institution towards greater heights. We welcome you, sir. Thank you.
So, respected dignitaries, good afternoon. So, I would like to welcome Shri Dinesh Verma ji, District Attorney Punjab, Advocate IPS Sabharwal, Deputy Advocate General Punjab and Haryana High Court, Advocate Mandeep Kumar Jethi, District and Court Session Ludhiana, and Advocate Dashwinder Singh ji, District and Session Court Ludhiana, and Advocate Akhil Kashyap ji. So, a very warm good afternoon to all of you. I, on behalf of Honorable Management of City University, feel immensely proud and privileged to stand before you today as we conclude what has truly been a remarkable and intellectually enriching 3 days Moot Court competition by School of Law held from 2nd to 4th April 2026 at City University. Over these past 3 days, our campus has witnessed an extraordinary combination of legal acumen, passionate advocacy and scholarly debate. This event has not only been a competition, it has been a celebration of legal reasoning, critical thinking and spirit of justice. More than 30 teams from diverse institutions have participated and over 50 distinguished judges have provided our participants with a rare opportunity to learn directly from them, who are from one of the finest legal minds. Your time, dedication and encouragement have made this event profoundly meaningful, and for that we remain deeply grateful to you, sir. To all the participants, I extend my heartfelt congratulations. Voting is not merely about winning or losing. It's about the courage to stand, articulate and defend ideas with conviction. You have upheld the true spirit of the legal fraternity, and I am confident that you will go on to become the torch bearers of justice in the years to come. I would also like to take a moment to appreciate the relentless efforts of our organizing committee, faculty members, student volunteers, and administrative staff. But a special thank to Dr. Aishwarya Neja, and who has led the entire event, and Dr. Tina Abrol, who has looked after all the administration part. At the same time, I must congratulate Vishwas also, the student president, and his team. They have done a wonderful task in the last 3 days and made this event a huge success. So as we draw the curtains of this grand event, I would like to extend my sincere gratitude to each and every individual once again who contributed to make this event a mega success. So let's carry forward the spirit of learning, collaboration and excellence that we have witnessed here over the past 3 days, and look forward to hosting many more such events in the near future. Thank you very much.
Thank you, sir, for your inspiring and thoughtful words. It is now my honor to invite our Honorable Chief Guest, Shri Dinesh Verma, District Attorney, Punjab, to address the gathering. Sir, your presence adds immense value to this occasion. We eagerly look forward to your words of wisdom. Please, sir.
Hello everyone. I am not here to speak about the law. वो आपको इन लोगों ने काफ़ी अच्छे से कराया होगा. मेरे को ये भी नहीं बोला गया था कि आपको स्पीच भी देनी है. चलो, anyhow, welcome to all the students who came over here throughout the India. I would like to say only one thing. आप क्योंकि अभी एडवोकेट बनने जा रहे हो, सबसे बड़ी बात, अगर आपने अपनी लाइफ में कामयाब होना है तो सबसे बड़ी बात यह है कि आपने अपने एल्डर्स पेरेंट्स की रिस्पेक्ट करनी है. तो फिर आपको कोई नहीं रोकेगा कामयाब होने में. मेरी कामयाबी जितनी को भी मेरे को मिली है उसके पीछे यही राज है. तो इसी बात को मैं यहीं पे कंक्लूड करूँगा. थैंक यू वेरी मच फॉर कॉलिंग मी. इट्स बी ग्रेट ऑनर टू बी हियर विद अमंग्स ऑल. थैंक यू वेरी मच.
Sir, we cannot proceed further without your words of wisdom. Please give a big round of applause for Advocate IPS Sabharwal.
It's really been an honor and a privilege to be a part of student faculty. I still consider myself to be a student of law after being in practice for more than 20 years. And starting from the district court, I reached High Court, then I started practicing at Supreme Court, now representing state in the High Court. Today it was really an honor to judge the event I was called for. I was really flabbergasted to see the representation, the research, the knowledge of law as represented by the students. I could not expect myself to be at such confidence level when I was in my student days. But it was really good to see that the confidence level the parties, the students had while representing their own cases. It was really an honor to judge an event like this. I express my gratitude, I express my regards for calling me here, and I wish all the best of luck to both the parties, to both the teams who represented their case, and all the very best of luck to all the other students also who did not reach the final rounds. Thank you so very much for calling me here. It was really an honor to come here. Thank you so much.
Thank you, sir, for your address. We now move on to the felicitation ceremony to honor our esteemed chief guests and a learned panel of judges whose time, expertise and guidance have been invaluable to the success of this competition. May I now request our respected dignitaries to kindly come up on the stage to honor our guests and the judges. Supreme Court and Punjab and Haryana High Court.
Yes, sir.
Advocate Mandeep Kumar Jethi, District and Sessions Court, Ludhiana. Advocate Dashwinder Singh, District and Sessions Court, Ludhiana. Then our chief guests of the day. So Advocate Mandeep Kumar Jethi, District and Sessions Court, Ludhiana. Advocate Dashwinder Singh, District and Sessions Court, Ludhiana. Advocate Akhil Kashyap, Supreme Court and Punjab and Haryana High Court.
Wait, sir, wait. Sir, wait.
Deputy Deputy Advocate General IPS Sabharwal, Punjab and Haryana High Court.
Yes, sir.
The Chief Guest for the day, Shri Dinesh Verma Ji, District Attorney, Punjab.
Yes.
Respected Chief Guest, respected advocates, faculty members and dear participants, a very good afternoon each and everyone. It is my proud privilege to propose the vote of thanks on this memorable occasion. First and foremost, I extend my heartfelt gratitude to our honorable Chief Guest, honorable advocates, for gracing this event with their esteemed presence. Your valuable words and insight have truly inspired all of us. My sincere thanks to our respected management like our Chancellor Sir, Pro Chancellor Sir, Honorable Vice Chancellor Sir, Registrar Sir, for their constant support, encouragement and guidance in making this event a grand success. I extend my appreciation to all the faculty members and organizing team whose hard work, dedications and coordinations made this event possible. Lastly, I would like to thank each and everyone individual who contributed directly or indirectly to the success of this event. So now we know that this is a competitions event for 3 days. And we know that this event we concluded as a successful, but without a team it is not possible. So I am requesting each and everyone to clap for Dr. Aishwarya ma'am for their leading this event. I am requesting each and everyone also to clap for Dr. Cheena ma'am. Thank you each and everyone. Thank you.
Thank you, sir. As we conclude this prestigious event, we celebrate not just the winners, but every participant who stood with confidence, argued with conviction, and upheld the dignity of the legal profession. This competition surely has affirmed that the future of the legal fraternity is in capable and conscious hands. On behalf of CT University and the School of Law, I, Nandita Agarwal, the Assistant Professor of Law here at City University, extend my heartfelt gratitude to all the dignitaries, judges, participants, and the organizers for making this event a great success. Thank you, everyone. We would be honored to host you again back at City University, Ludhiana.